Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Sadkovich from ZFZ. Welcome, Calum.
Hey, Luke. How are you doing?
Good. Well, today, super excited because we've got a special guest.
A very special guest. Our first external barrister guest.
It's only taken us how many? 50-odd episodes to have a barrister on. I think we've kind of warmed up enough, Calum, to have a senior junior barrister join us for today, and we've got none other than Matthew McGhee from 20 Essex Chambers. How are you, Matt?
Yeah, doing very well, thanks, Luke. It's a genuine privilege to be on this with you guys, and I'm only slightly intimidated by the fact you've done so many episodes and are a well-oiled machine now at this. I can only hope to match your output.
I think there's sort of mutual intimidation going into this podcast, which is where we always want to be.
Very good. And for those of you who are listening in, and number one, thank you for joining us. Always pleased to have you listening in. And for those of you who do not know Matthew, he's an experienced commercial barrister. We've worked with Matt on various cases, ranging from shipping through to commercial matters, through to fraud-related cases. We've had some agent broker cases in there as well, a full range of matters, and I'm sure he can expand on his experience if he so chooses, but pretty much anything in the commercial litigation sphere, I think it's fair to say Matthew can work on it.
Yeah, it's been a pleasure working with you guys, and actually, as it happens, I was quite pleased, slight ego boost, that one of my cases in High Court ended up on your podcast.
Yeah, I remember it.
Last year, which was good fun.
I remember it. Well, which case was that?
Stella Primorge. Happily, it's one that I won. So you both very much agreed with me, although Calum, I remember you had a few comments. You seemed to have some sympathies with the other side.
So which one was that one?
About leaving on birth due to there being insufficient clearance.
Yes, I remember that one. Yeah, I liked that case. It was an interesting one. So in a sense, you've been on the podcast before because we've been through your work, but we've just not had it straight from the horse's mouth.
We can test it live now.
Yeah, well, it was a little bit of trepidation there. I'm like, oh, hang on, did we side with the other side on this one that Matt had previously? But yeah, sometimes we do. Sometimes we well, if you've listened in before, you'll hear that we sometimes have opinions. They're only personal opinions, of course, and just kind of as commentators on what we may think of certain findings or arguments or what have you. But that's the fun of this. And today we're dealing with a case, correct me if I'm wrong, that you've not been involved in, Matt. Is that right?
Correct. No, I've not had any involvement, so opinions of my own, and I'll be free with them.
Very good. And we're going all the way over to Hong Kong for this case, which is another new step for us on the podcast. It's a decision in the final Court of Appeal over there in the Hong Kong Special Administration region. So it's going kind of up through the appellant levels in Hong Kong. And this is the case of PT Tugu. There are some other parties there, but that's the main one. And Citibank. So we're in banker customer territory here, looking at the duties that a bank owes to its customers, and when causes of action may or may not accrue in that context, and importantly, whether causes of action have accrued for the purposes of limitation periods. And this case is all about whether the 6-year limitation period over there kicks in or not, whether the bank is able to rely on the limitation period, or indeed whether the customer can take out its funds whenever they want, even if they've been unauthorised to be paid out by others. For those who like citations, I'll give you the citation as well. This is 2023 HKCFA 3. And court file number FACV number 11 of 2022. It's a relatively recent decision. The hearing was heard in January 2023, and we had a prompt judgment within a month on the nose, issued on the 6th of February 2023. Lord Sumption NPJ gave the leading judgment, and 4 other justices, Chief Justice Chung, Mr. Justice Ribeiro, Mr. Justice Fock, and Mr. Justice Lamb also agreed with Lord Sumption. So we've got a unanimous decision here, guys. Who would like to kick us off with a bit of background on this one?
I think so. Just before we get into the background of this case, I think I might pass to Matt, not to put you on the spot, Matt, but there's an interest as well in this area of law in the English courts. Recently, I think there's maybe a Supreme Court decision coming out at some point soon on similar issues. Am I broadly right on that?
Yes, this is quite a fun case, and it's interesting seeing how this particular concept's being developed, deployed in different jurisdictions around the world. But part of this judgment in Tugu concerns the Quince care duty, and that is the duty owed, probably, we'll scale onto that, by banks to their customers. And it's the subject of an appeal here in the Supreme Court in Philip and Barclays. Now, again, I've got no involvement in that, so no inside information, but it was held on an expedited basis earlier this year. So I would assume judgment's going to be out this side of the summer, but we'll wait and see.
So there may be more on this area in the not too distant future. So, with that said, shall we get into the facts? Do you want to go take us through the facts, or do you want?
Sure, I'll have a quick run through. It's quite nice in a sense. It's a refreshingly short judgment, which is always nice to read. And the facts can be distilled down quite quickly, in a sense that the claimant was an insurance company, and it operated mainly through a few of its officers. And these officers went along to Citibank, or at the time subsidiary, and set up a bank account for the company, which then received a lot of money which was receivable by that company. Unfortunately, that was where things were conventional. It then went unconventional because the officers just took all the money out themselves over the course of 4 years. So over the course of 4 years, 26 transactions, the fraud of about $56 million all told. And the question then was, obviously, the customer wanting to get their money back. So there are lots of issues that then come up in the case, mainly because it all happened very historically. And I don't know the precise reasons why it took quite so long to all get uncovered, but the transactions all took place, and then the fraudulent directors closed the account with Citibank. And then it was only, and that was all in the late 90s, and then it's only very recently come back to life in 2006, I think, was the first demand by the customer telling Citibank, all that money that you received for us and then wrongfully paid out, we'd quite like to have that, please. And Citibank refused, and the claim was issued the following year. So that really kicks off the limitation issues that we touched on.
And it seemed as though it was pretty well agreed that after the first 2 payments out, we can get onto this in a little bit, because I'm interested in your take on this part of the case. Even though I sensed that by the time it reached the kind of top court in Hong Kong, it was, this wasn't really where the case was won or lost. But it was pretty well agreed that the bank should have done more to make inquiries into what was going on after the first couple of transactions had taken place. And really, there's a kind of admission of some kind of culpability on the bank side, but the big defense the bank was raising was that it was time barred. And effectively, the way that the time bar worked was such that when the transaction happened, if the cause of action arose when the money was paid out in these installments, then it was time barred. If the cause of action arose when the bank was when the bank account was closed, then it was time barred. But if the cause of action arose when the actual customer of the bank went along and made a demand to Citibank and said, actually, I would quite like that money that you've paid out to all the officers, if that was the point in time at which the cause of action arose, then the claim was not time barred. And the court of first instance and the first appeals court had all found it's time barred. Basically at the latest on the date on which the account was closed. And I think they both found the account was properly closed we can get onto this as well, because there was some interesting debate on that. But for that reason, the first instance court and the first appeals court decided that yes, there was liability, but it was time barred, so no recovery for the bank's customer. Supreme Court went a different direction on it.
Yeah, and just before we get into the limitation point, Calum, and almost reiterating what you said on the underlying liability, this concept of being put on inquiry, I just wanted to touch on that briefly at the outset. And this is just more by way of observation than anything else, because it's not a key part of this particular judgment. But is one of the reasons, just looking at it, I suppose, why after 2 payments out, the bank should have been put on inquiry, is because we're dealing with an Indonesian state-owned oil and gas company. And it seems like quite an unusual situation where you would have a large oil and gas company, state-owned, which presumably the bank would have had that information as a part of its account opening processes, and within a short space of time, significant payments were being taken out of that account, paid to individuals who had opened this account. And it's the kind of thing which you think, well, that's a bit strange. If it was privately owned, if this was a privately owned company and this was kind of like the head bank account, and dividends are being paid out to individuals, you can kind of understand it. But the fact that it's state-owned and that such substantial monies were going out into personal accounts, it seems like, that is at least worth asking some more questions, right?
Yeah, and you have and this I think is we're kind of going into the Quince care duty that the bank has, which is a weird duty on its face, because the bank has to do something different than what it's been asked to do by people who purportedly have authority to ask the bank to do one thing. The bank has this kind of overarching duty to say, actually, hang on a minute, that doesn't seem quite right. We're going to not do that, and to look into the background of the transaction, and we're going to ask some questions. And if the bank failed to take those steps, then the customer can turn around and say, well, those funds were, or that transaction was processed without actually asking you to do it.
Yeah, absolutely. And this will be really interesting, not only to drift away from this case, but it would be really interesting to see how this point is played within the Supreme Court in Philip, because the juridical nature, the basis of the Quince care duty has never really been explained in the Supreme Court, or indeed the House of Lords. So this is the first time they've had a chance to really engage with the nuts and bolts of why it operates and where it does. And there were certainly some comments in the hearing that seemed to suggest that the Supreme Court was very alive to that. So it'll be interesting to see how they try and spell out the difference here. But in terms of how it's been operated by the Court of Final Appeal in the Tugu case, Lord Sumption goes about setting out the basis of the Quince care duty. He says that it operates in a very general sense. What he is talking about is solely a reflection on the way in which a banker-customer contract operates. He then goes on to say that this case is squarely about a corporate customer, but his comments don't seem limited to that. What he then goes on to tease out is essentially that the way in which the bank operates, the bank is simply a debtor to its customer, and the only difference between a standard debtor-creditor relationship is that the bank has this additional obligation as an agent to honour demands by the customer to pay at its direction. And it's that added obligation, which is the one that carries the implied duty of reasonable care and skill, which then forms the basis of the Quince care duty.
So just to emphasise that for those listening in that might not deal with banking cases or know much about the Quince care duty, just to kind of put an exclamation mark on that point, what you're talking about there is that the bank and the customer have this additional relationship, one of agency. And it's because of that relationship that there's an additional obligation, if you like, on the bank to think about the instructions that it's receiving, the orders that it's receiving to make certain payments. And this concept of, because you kind of always is the wrong word, but as a layman, you think about, a bank account as I've got actual dollars sitting in a bank account somewhere in a bank, and they're there for me whenever I want to use them. And it's not actually that, is it? It's a debt. It's a debt arrangement between customer and bank, and the customer gives instructions to the bank or makes demands to pay in certain ways, and the bank is obliged to follow those instructions. So it's much more like a debt and kind of relationship than anything else, as well as the agency one.
And this ends up being a really key point later on in the judgment when looking at the limitation period. So I think it's an important point to stress is that, you know, if you go along to the bank and you deposit £100, you don't have £100 at the bank. I mean, colloquially you do, but in fact you have a debt. You have an action in debt against the bank by which you can say to the bank, you now owe me on demand £100 I've given to you, or I've deposited with you. So you're right, Luke. It's not. I guess the bank's not holding that £100 as a bailee for you, or anything like that. The bank is instead saying, I will pay you back £100, seeing as you've given me £100.
Exactly. It's not like you've got two $50 notes sitting in a lockbox at the bank. That's not the situation, right? It's the ability that the bank to instruct the bank to pay $100 to your order somewhere, and that's really, really important conceptually to understand that, because if the bank goes and makes payments that are unauthorized, that were not properly authorized by the customer, the bank still owes that $100 debt to its customer. Doesn't matter these other payments that have gone out. It's almost irrelevant. It's beside the point. That's a problem for the bank to deal with. When the customer turns up properly and says, I want you now to pay the $100 here, the bank's liable to do that.
I think there was a nice phrase on this where they said, Lord Sumption said something along the lines of an unauthorized debt is a nullity, which I quite like to, as a way of summarizing that point that you're making there, Luke, which is if all these transactions are unauthorized, then the effect is simply that the bank still owes the original debt back to the original depositor.
Yeah, and I think it's important to emphasize this at the outset because it kind of sets the platform, that banking 101, what's the nature of the relationship type question, I think sets the platform for then looking at the limitation issues. So, Matt, perhaps if we take it back now to like the key issues in this decision on limitation and kind of set the scene on that point.
Yes, and actually your sort of delving into the nature of the relationship is really key, because that was the whole plank on which Lord Sumption built his judgment by saying this is all about debt, and as Calum said, Calum quoted the 90 point, that the position is where the bank has paid this money out not legitimately, not according to its customs instructions, then it still owes that debt. And the breach of mandate issue, which is when a bank pays out not in accordance with instructions, simply means that those are payments out of the bank's own money. It's not a claim for damages or anything of the sort. You just say you made these payments, that's very interesting, but it doesn't affect the position as between us. And really that was key, because it followed the whole way through the judgment. The issue was one of limitation, and the bank was trying to come up with ingenious arguments. You do have to give the bank some credit, I think. They came up with some pretty intelligent arguments.
And they won on the first instance, and they won on the first appeal.
I suppose the lesson is never give up.
Yeah. Try again.
But what they were then saying is, to get around this issue, the Lord Sumption said the answer is the claim is in debt, and the bank is essentially being held in a situation where it will always be liable, and it'll be liable indefinitely until such time as its customer demands the money, and the bank's not got any way out of that. And the bank's best argument, which they did succeed in, including on first appeal, is to say that actually we're not too concerned about the wrongful payments out, which we now accept are wrongful. Luke, you made the point that the bank was on inquiry, but it instead focused on the closure of the account.
Yeah.
And this is actually, I think, a really interesting point, because it's one that I did not see or come across before. The bank thought there was no money left in the account. It thought wrong because of the breach of mandate point, but the bank therefore purported to close the account in accordance with the fraudulent instructions. the way in which the bank then tried to run this as an argument on appeal was to say that that was a wrongful attempt to close, and that was a repudiation of the banking contract. But because the bank said there was no point in keeping the contract afoot once the bank had repudiated it, the bank said, well, this falls in that very exceptional small category of cases where you have a repudiatory breach by one party and then the innocent party doesn't actually have the option to affirm the contract. So the bank's essentially saying we can unilaterally terminate our banking relationship. And that argument was, as you say, Calum, one that worked on first instance and on appeal and gave them a complete limitation defence. But law sanctions stenciled it pretty quickly.
Yeah, and these are the law school case that I remember is the White and McGregor case, which I think was an advertising agreement. Someone that there was some kind of deal there. I might be getting this totally wrong. If there's anyone listening who goes to law school and is just studying this case in their first semester of contract law, then they can write in and tell me how wrong I'm getting it. But I think it was something along the lines of someone had agreed to put some flyers up all over town or something, and there'd been a repudiation, but the person who had ordered the flyers said, no, I insist that you have to still go and do it. And the person who was supposed to put the flyers out said, well, I'm not going to. And instead of accepting the termination of the contract, they said, no, I require you to. We're going to affirm the contract. And the court said, no, you don't. You don't. In those circumstances, there's no benefit whatsoever to you continuing the contract. So the repudiation, the normal. In the normal way of things, if there's a repudiation, then you have the option either to say we want to terminate the contract because we're through with this relationship. You've repudiated the contract, or you can say you've repudiated, but I'm still going to hold you to the rest of your performance. And we see this sometimes in the shipping context. That question comes up in various guises. But I know that one of the other. There was a MSC case recently, which was also in that kind of narrow category of no right to affirm, which, as you say, Matt, the bank here was trying to say we fall into that category too, because there was no reason for them to want to keep the account open after we had decided that it was closed.
Yes, and Lord Sumption's answer on that point was, paraphrasing slightly tongue-in-cheek, but essentially the benefit was being able to not be time-barred.
Yes.
That's essentially his argument. Because he said, well, actually, if you think about it, the repudiation itself might have been a breach of contract and you might be able to claim damages, but at that time, no loss has been suffered by the customer, so there's nothing they can claim. Their only interest with the bank is the right to claim the debt, and that can't be claimed as damages at the time of repudiation. So that's by the by, and therefore there is a legitimate interest in continuing to keep the contract afoot.
Again, I'm sorry to bring it back to kind of first principles, but doesn't that go back to the point that a customer can give an instruction to the bank to pay wherever it wants, whenever it wants. And if he wants to leave its money sitting in its account for 10 odd years before touching it, then that's the point. I think they said that's the part of the bank's business, where they might not like it. It may be inconvenient. It may mean they can't cut off claims in a way, or at least put a full stop to get things running on limitation periods. But that is the nature of the banking business, that it continues on.
Exactly, and just kind of drawing that even further, the idea, and this comes full circle to what you just said, Matt, but the idea is that there's no loss suffered until the demand that cannot be complied with or is not complied with is made. So the customer goes to Citibank eventually after all these years and says, "Okay, I'd like money, please." And Citibank says, "Well, actually, we've your account is showing nothing because we've distributed all of that money on the basis of other instructions." And then we close the account, and the customer says, "Well, hang on a minute. Actually, I would quite like the account still to be there, and I'd also quite like the account still to have $56 million in it because then you'd owe me it as a debt." And I can kind of sympathize with the customer who is saying, "Well, these people who were put in charge of the bank account have drained it of funds and then closed it, and you're saying that that act is the thing which prevents us from that act that happened without our authority is the thing that stops us being able to make a recovery because it happened so long ago. Whereas actually, what we really want to do is recover against the demand that we just made a year ago. So I'm interested in your take on this as well, Matt. Sometimes I think you often, I say this with complete respect for all of the judges across all of the different courts, but I think sometimes you see a decision where the right outcome has slightly been facilitated by a way of looking at the law, which is, maybe they distinguish from some other case, and they guess what I'm trying to say. Sometimes the judges can find a way through that gets to the quote unquote right outcome. And I think here we definitely have the right outcome. But also my sense from reading this is that it is not a hugely controversial route through legally either. And I almost say that in the sense that I was slightly surprised that this wasn't the decision on first instance and the appeal. It feels like not only is this the right outcome kind of morally, but also it feels right in law that this is how that the cause of action arises at the point where the demand is made to the bank. Interested in your take on that?
Yes, I agree. I fall back on the position that I like to think that the law should make sense and it should reach the right outcome. And judges are human; they want to reach what they see as the right outcome. But what's right, I suppose, can reflect the way the case will be put to you, perhaps at the earlier stages. Inevitably, looking back at it now, we've seen 3 judges all give their own colour on it. The latter ones commenting on the former ones. So perhaps things have moved slightly along the way. But I agree with you about it being the right outcome. It does seem to be a pretty conventional way through. That said, perhaps I said earlier, the judgment was refreshingly short because the beguiling in simplicity, because Lord Sumption's comments are not 100% free of controversy. There's a very well-known barrister, commentator, academic, Peter Watts, who's put an article out saying that actually some of the analysis is not 100% correct on the agency points. And the other point which jumps out at me is Lord Sumption tries to bring together a slight departure between the Hong Kong courts and the English courts on the question of agency, reasonable notice, putting on inquiry, where actually the Hong Kong court in a case called Akai Holdings said one thing, and then the Privy Council, obviously English-based, said actually that they've sort of gone a little bit away from the orthodoxy, and in the case called East Asia said actually that's wrong. And Lord Sumption tries to bring the two back together and says actually the Privy Council misunderstood what we did in the early Hong Kong case. So there's a little bit of room for manoeuvre still, but I agree with you. Just picking up on the point you made about getting to a right outcome though. Another point which is sort of a bit off the beaten track, almost a throwaway comment in this judgment because it's not relevant, but the earlier judges at first instance and the Court of Appeal said that the customer was 50% liable. In the event that there was no limitation, the customer would be 50% liable for the customer's contributory negligence, which I thought was one, a very interesting comment to make at all, and certainly something that I think would be of great interest in England in any sort of Quince care type claims, but also 50% is quite a high bar. Yeah, quite a high level to be pitching at.
It's quite a chunk, to me this gets back to the Quince care duty, and this is where I sympathise. I'm in the famously loved position of sympathising with major banking institutions here, because the bank is basically given a list of people from this company who can act as, on behalf of the company in instructing the bank. Those people then come to the bank and they say, we'd like you to do this with our money. And the bank then has to say, should I do that or should I not do that? And obviously if the bank said, I'm going to decline to follow your instructions, then the bank could be in trouble. That can be a breach of contract. That can be the bank not acting on what it's supposed to do with this debt that it owes the customer. But on the other hand, if the bank goes ahead and follows the instructions, then later on the actual customer or the customer can turn around and say, well, yeah, so we did authorize those people to give you instructions of what we should do with the money that's in our account. But in that instance, they weren't doing what we wanted them to do. So we're going to kind of claw that money back again off you. It puts the bank in a slightly difficult position where it has to, on the one hand, follow the instructions of somebody who is nominally authorized to give them to give them instructions on what they do with the money in the account. But on the other hand, also says, but sometimes don't follow that instruction. And I suppose the distinction I draw here is it's not like it's not like somebody else turned up and said, I am actually this person, and they didn't check, the person's ID, and they just went ahead and sent some money out. The people who were giving instructions to the bank were the people who were authorized by the bank's customer to give instructions on behalf of the customer. It's just that the instructions they were giving were outside of the authority that company had allowed them, which is it feels like a narrow path for the banks to walk down.
Yes, and perhaps here we can make Luke the arbitrator, because my natural inclination is actually the other way around, in the sense that the Quince care duty, as it's evolving, as it's potentially applied here, I think it makes a great deal of sense to me. As a duty, it makes sense that if, as a bank, you ought to have been on notice or on inquiry, perhaps more properly, that the signatories were doing wrong, then you shouldn't follow the instructions blindly. And I don't have any great issue with that as a matter of principle. Where I do see you've got to be sensible is obviously not making banking impossible for the banks. But the safety valve there is that the test is what would a reasonable and prudent banker do. And that is really the key bit that we need to focus on, that's received not too much attention to date. But going all the way back to what Luke started talking about at the very start of today, that was about saying that the first couple of transactions were fine. They were on the face of it authorised, but it's only the later ones where it started to become a bit suspicious, looking at the whole scheme of what's gone on. And perhaps just taking a step back, looking at this case, it doesn't seem wholly surprising to me that a reasonable bank probably should have thought, sending 50-something million to the officers with absolutely no other activity on this account does look a little bit dodgy.
It is a somewhat dodgy. But yeah, I totally see that. And I think the point of interest is around what it means to be on notice.
I'm enjoying hearing your back and forth between the two of you, Calum and Matt. And I think I lean more towards Matt on this one, if there really is a distinction between the two of you. But it's this balance, isn't it, between putting sufficient obligations or an onus on the banker to act reasonably. I don't know whether there's a distinction here really between irrationally and unreasonably, but kind of parking that to one side for a moment. It's this kind of balance between the banker acting reasonably, and if there's something that looks untoward, to take some steps to identify it. Now, that doesn't mean that the bank necessarily needs to find out that the actual position, does it? It means that the bank then needs to take some additional steps to satisfy itself. And I think that is a reasonable duty. I think that makes a lot of sense. And this reminds me a little bit, Calum, of that case we looked at recently in the crypto space, where you're looking at a relationship where the bank has a lot of power, they have a lot of responsibility, they have to take care with very often very valuable, especially in this case, valuable asset of the customer, and the customer is relying on the bank to conduct its role reasonably and take certain steps and be on the lookout. And so it's balancing that obligation on the bank to act reasonably and carry out its duties as a banker, with not being too onerous on the bank. And it would be impractical for a bank to have to go and check every single thing to the nth degree. It would just stop we've all experienced the frustration of having to ring a bank and go through a second check, and a second check's like, yes, you've got my birthday, you've got the name of my dog, you've got my first car, you've got everything, this is me, and then they still say, well, we want to check something else. Can we send you a passcode? And it's to where do you draw the line, right? And I think that's what the court's saying here is there's got to be some limit on a bank, otherwise you stifle banking itself.
Yeah, I was going to say the limit seems to be those situations where you the position is there's something that jumps out or would jump out to this reasonably prudent banker. I suppose cynics would say that they're yet to identify a reasonably prudent banker. But you have to have this kind of exceptional situation where there's something that should be ringing alarm bells. It's not a case of the bank should always be on inquiry and they don't need to be alert to every single little thing and constantly checking every single transaction. But if something is flagged that makes the bank go, oh, hang on a minute, then they do need to look into it. That's when they are on inquiry.
That's all absolutely right. The only sort of slight note of caution I'd sound is we obviously are limited in what we can see by what actually gets made public.
Exactly.
And probably there are plenty of other cases which are compromised at some earlier stage where the facts are a little bit murkier.
Yeah.
So we've got to assume that there are unknown cases going on, unknown factual setups, which might not be quite so cut and dried. But certainly we can take some bits and pieces from this judgment, from the other judgments where these sorts of issues are coming up and start to piece together the sort of things that are relevant. And it does seem that there are big obvious points that are clearly going to be triggering an inquiry duty. One sort of personal pet project of mine is thinking about the sort of degree to which you can look to the bank's AML systems and what should be being triggered by their systems to seek to establish some sort of liability.
Oh, in a case where you're seeing millions leaving a bank, then I think that might trigger some warning. But the reality is that the overwhelmingly massive majority of payments are automated. So who is this reasonably prudent banker that steps in and says, actually, this one seems like it's a bit odd? You're really looking here at processes that banks put in place to trigger the alarm bells to basically, some way of flagging you need to be on inquiry for this transaction.
Yeah, I think that's right. And essentially, we could end up with a case that we've seen one yet, not quite, we'll go on to that perhaps, but one where actually the case is being run saying the bank system was just fundamentally deficient and should have been triggered by this and wasn't, and it was allowed to go through automatically. But any reasonable and prudent bank would have their system set up that they would have flagged this sort of transaction. And we sort of were getting towards that way in a decision last year, a case called Techmont in the English High Court. But that point didn't get explored in too much detail, mainly because the judgment ended up going off in a slightly different direction. But those sorts of cases, I think, are starting to come through.
I was saying, I've just been trying to Google what happened to the officers involved. I don't know if either of you have managed to find anything. I can't see any news report about them being hounded by the bank, but presumably the bank would have a claim against these three officers flowing from this claim for a fraud perpetrated against the bank. Query whether that one was time-barred.
Yes, that would be quite awful for the bank. Limitation arguments are bouncing back on them. But yeah, there would be a way, the conspiracy claim or deceit claim, but it would be a claim in tort, is probably how it would be framed. So they would have that issue.
Very good. Well, look, my parting shot on this one was those I'll say few, but it's more than a few times when I've had to call a bank up having cut my card down or stopped a payment, and sorry, I'm getting a call. My parting shot on this case is those times when I've had to call a bank having had a payment blocked or a card held or something, and then having to go through the fraud team and say, yeah, this is fine, I authorise this. When that happens now, I have to be thinking about the Quince care duty that the bank has. And I urge all of you out there, when you have that moment of frustration, it's like, oh, I'm in whatever place it is around the world and my card's being blocked at the restaurant and you forgot to tell the bank that you're going on your travels. They're doing that because they're trying to fulfill their Quince care duty. That's my parting shot on this one. Any other thoughts, guys, on this case, or more generally?
They're helping out on their duty to you.
Matt, anything else that you want to say on this case?
I think just one final point from me, perhaps, and that is again something which was shadowed in the judgment, but could be of wider interest. One of the claims which was initially advanced was saying actually the bank was dishonest, and that was presumably a way to try and get around the limitation issue. At first instance, the judge said no, there was no dishonesty. It didn't quite reach that level. It was just something less, negligence perhaps. But dishonesty of banks is a really interesting topic, particularly when you tie it with things like the AML systems and what the bank should know and what a reasonable bank should know. And again, that's something which potentially is going to be a bit of a blue area. Interesting
food for thought. I hope that we will be able to have you back on, Matt, when the Supreme Court adds to this body of law in the not too distant future. Thank you very much for making the time. We really do appreciate it. It's been very interesting conversation, very interesting case. So really, really do appreciate your time.
It's been an absolute pleasure. Anytime.
Really enjoyed it, Matt. Always good to catch up. Thanks for your time. And thank you everyone for listening in. If you're hearing this, you've joined us till the end. So thank you. We do very much appreciate it. Please do like and share the podcast episode with your contacts. That'd be greatly appreciated. And particularly if you could subscribe to us on the various platforms that you listen to this on. Until next time, take care everyone.